Ms. Wyrick, can you hear me?
Yes, Judge, good morning.
Good morning. Mr. Reagan, can you hear me?
Judge, I can hear you. Yes, sir.
All right, thank you. Are you already on the James Britton matter?
I'm ready, Judge.
Yes, Your Honor.
All right. This is Mr. Britton. Can you hear me?
One more time.
All right. This is State of Michigan versus James Britton, case 25059371101. Today is the date set for a bond redetermination hearing. Bond was set intentionally unaffordable. Can I have appearances, please?
Good morning, Your Honor. Sherry Wyrick on behalf of the people, P77976.
Judge,
Good morning.
Please, this honorable court. Excuse my camera, Judge. Please, this honorable court, Philip Reagan, P5716, James Britton, who's appearing via Zoom for purposes of bond redetermination, Your Honor.
All right, Mr. Reagan, you're a little choppy right now. Do you need a second? I want to make sure we hear it.
Yep, Judge, give me 1 second. I'm trying to clear this up.
That's okay. Just let us know when you're ready.
Okay, Judge, can you hear me now a little better?
I'm sorry, I can. All right, today is the date set for our redetermination here. I'm sorry, go ahead, Mr. Reagan.
No, I was saying, can you hear me a little better, Judge?
I can.
Okay, great. Wonderful.
All right, today is the date and time set for the redetermination hearing. Ms. Wyrick asked to bond.
Judge, I do think the 500,000 cash surety that it's currently set at is appropriate in this case. The defendant is a danger to the community as well as to these victims. This is an incident that took place in a senior living facility. 3 people were shot. He attempted to shoot the 4th person, but was tackled. Wrestled the gun away from him, and then the defendant was ultimately shot. This is obviously a dangerous incident that took place. Several others could have also been hurt. His priors go all the way back to 1966, Your Honor. Armed robbery, willful killing, other weapon. In 1978, he was found guilty. Let's see. It's his most recent, I believe now is 2018 felonious assault with a dangerous weapon. But Your Honor, these charges are very serious. There were 4 victims that were involved. 3 of them were shot, and they all live in this community. And so not only is he a danger to them, but he's a danger to the community.
All right, thank you, Ms. Wyrick. Mr. Reagan asked to bond.
Judge, so there's no question that Mr. Britt can't go back to that location. He's 78 years old, Judge. As Ms. Wyrick talked about, he does have priors back to 1966, Judge. He's almost 80. He's on Social Security. Obviously, we have a little bit of a different spin on what happened. You're just talking to Mr. Britton in terms of him being the one that was shot, not initiating anything. $500,000 cash, Judge, we feel is excessive. I don't think he's a flight risk. He's not going on anywhere, Judge, but I do understand the other aspect is danger to the community. Now, I think that if the court did isolate Mr. Britt put him on a GPS tether to another location. I think that would suffice, Judge. He's 80. I don't think he's a danger. I'd ask you to reduce his bond to something more reasonable, if not personal, with the GPS tether.
All right, thank you, Mr. Reagan. Give me one moment, please. All right, I've had a chance to review some of the previous history as well as the investigator's report. In this matter, the defendant is charged with assault of crimes involving at least three victims, and I believe at least one of those victims was shot. And Ms. Wyrick, correct me if I'm wrong on that.
Three individuals were shot, Judge.
3 individuals were shot. I would also note that in 2018, there's a conviction for a felony assault with a dangerous weapon. The defendant is also not a CPL holder. This incident takes place at a residence that is under the defendant's name, and I see the complaining witnesses also live at that residence. I do believe that there is an established threat or danger to not only those victims, but the community at large. Bond is set intentionally unaffordable and will remain so. Bond will be continued, all conditions set at the arraignment stay in place. Mr. Britton's next date, 1 second. There is a probable cause conference scheduled for August 28th at 8:30 before Judge Taylor, and there's an exam scheduled for September 3rd, also before Judge Taylor. These are at 8:30. Is there anything further as to this matter?
No, thank you, Judge. Have a great day.
No,
too.
thank you.
Good to see you. Thank you, Mr. Reagan, and thank you, Mr. Britton. That concludes the hearing. Mr. Banks? Mr. Banks, can you hear us?
I actually don't have Mr. Banks on. I'm gonna.
Oh.
Once
Mr. Hall?
Once Mr. Graham's done, I'll go log Mr. Banks in.
Oh, appreciate it. Mr. Hall, are you available?
Yes, Your Honor.
Okay, I'm gonna call Mr. Hall's case. And right. All right, this is State of Michigan versus Brandon Hall, case 25059390202. Today is the date set for a bond redetermination hearing. Bond was set intentionally unaffordable. Can I have appearances, please?
Good morning, Your Honor. Nicholas Davis, P 88380 on behalf of the people.
All right, thank you, Mr. Davis.
Judge, and Philip Reagan on behalf of Mr. Brandon Hall, who is appeared to be assumed for purposes of bond redetermination.
And thank you, Mr. Reagan. And Mr. Hall, good morning. Today is the date set for a bond redetermination hearing. Bond was set intentionally unaffordable. Mr. Davis asked to bond.
Your Honor, this is a case involving the use of firearms to commit a carjacking. Firearms were recovered by state police and executed a search warrant on this house. The victim indicated to police that he had firearms pointed at him and that he was threatened with being shot if he did not turn over his vehicle. It is the people's belief that the defendant represents a danger to the community based on his possession of firearms and his demonstrated willingness to use them to commit violent crimes, in this case, carjacking. In that regard, the people would request that bond remain unaffordable in its present state.
All right, thank you, sir. Mr. Reagan asked to bond.
Judge, well, you know, Mr. Hall is 18 years of age. He does have some juvenile stuff, but he lives in the city of Detroit. He has strong ties. He lives with his mother and his family here. Judge, I do understand the nature of the allegations. But again, Judge, I'm asking the court to consider reducing the bond. The bond is $100,000 security. I asked the judge to personal bond with the house arrest so that Mr. Hall will remain inside during the pendency of the case, Judge. But one of the things I'm asking for is personal. He's 18 again. So that would be my request to the court, Judge.
All right, thank you very much. Give me one moment. All right, I've had a chance to review the investigator's report. Was there anything from the people or from the counsel for Mr. Hall that needs to be added? All right, are there three defendants in this? One a juvenile or?
Yes, Your Honor. There are two defendants that we've charged, and one was charged as a juvenile. I'm not handling that one. I'm handling the two co-defendants. The other individual, I believe the name is Braden Paul, who is.
That's correct, Jeff.
Yeah. Is what else do I want to ask? Mr. Hall have an adult record?
Your Honor, I believe, looking at his criminal history, he has been charged in previous cases. However, they were dismissed. He has prior charges for felony firearm, home invasion.
No convictions?
No conviction. He has a juvenile adjudication for one crime, but no convictions in adult court.
All right. All right, I've had a chance to review the investigator's report and trying to piece together what is before me. I would note that this is involved. This is an alleged crime involving a weapon, and I have three individuals. I believe the oldest in this case is 18 years old. However, at least according to the investigator's report, this is not an incident involving two people fighting. This is alleged to be a purported setup to rob, with someone being demanded of their property over gunpoint. I do believe that there's been a dangerous situation established. The fact that tools of the incident, including a weapon, are found at the residence of Mr. Hall, as well as surveillance to that area and the area where Mr. Hall lives, and an idea that he's from someone else that he's in that car at the time. So bond is going to remain intentionally unaffordable at $100,000 cash or surety. Mr. Hall, your next date is going to be August 27th, 2025, before Judge Giles. August 27th, before Judge Giles. Sir, I see you have your hand up.
Yes.
Do you wish to talk with your attorney in a private room?
No, I was gonna see if I could ask a question. I tell you.
Well,
What do you
sir,
want to
Mr. Hall, I got to remind you of your right to remain silent. Anything you say right now could be used against you. If you want to speak, I would strongly suggest that you speak through your attorney. Maybe you want to tell him in private, and then he can tell me to make sure that you're not saying anything
Early
that
on.
hurt you.
Yeah, we early on.
What's that?
You want to ask the question, Mr. Hall?
Yes.
Okay, because we're early in this. I don't want you to say anything. Judge, could you put us in a breakout room?
Yeah, sure. 1 second. Mr. Reagan, should I get out Mr. Hall?
Yep, get out, Missy, if you could, Judge. Thank you. Judge, I think one of the things Mr. Hall wanted the court to know is that he has two daughters that he's trying to get home to. You know, he's trying to take care of, he's trying to get back to work. A lot of these circumstances that the court read in the investigator's report are not accurate as to his situation, to how he's involved in any of this. So I want the court to understand that. And I want to say that on behalf of Mr. Hall, Judge. He's trying to get home. If we could consider lowering the bond some way, shape, or form, I respectfully ask the court to do so.
Well, I got to say, from reading the investigator's report, there are inconsistencies, and Mr. Hall's involvement with this, you know, I would indicate as a little bit of a lesser degree than some of the other folks are involved. But you know, this is a carjacking, and on top of that, you know, Mr. Hall happens to live with in the same area where some of these things were recovered, and was allegedly a part of the crime. So that's why my ruling stands where it's at. Bond is going to remain where it's at. But I take that into consideration, Mr. Reagan.
Thank you, Judge.
All right, that concludes the hearing.
Thank you, Judge.
I got shit to add.
Your Honor,
Hello?
how you doing, Your Honor? This deputy here. Is there any way for Mr. Davis to speak to an attorney before you actually go before him?
Sure.
Thank you.
You guys wouldn't happen to have Mr. Banks up yet, would you? Nope. So 1 second here. Might be a minute before they get the second guy. Actually, I'm gonna do this. Mr. Davis, can you hear me?
Your Honor.
Say it again.
Yes, Your Honor.
Let me call the case first. And if you have to speak to your attorney, I'll let you speak to your attorney. And we can take it that way. But I won't let you get out of here without letting you have that opportunity.
There's some things I wanted my attorney to say to you, but I could say them without eating my own words. And that's the words I should use. I mean, with me being on parole and all, but I'm gonna let my attorney speak for me. But there's a few things I would like to add, actually.
All right, Ron, we'll do it that way. Let me get you in the room. Mr. Reagan, can I put you in the room with Mr. Davis?
Sure, Judge. Absolutely.
You got anybody out yet?
Did you put me in yet, Judge?
Join room 1, Mr. Reagan.
I'm trying. It's not coming up. Join. Let's see.
I gotta bring him out and bring him back in.
Man, you see how smooth, or how other courts waiting.
He never came in breakout room.
Try it again, sir. See if you can join room 1 again. I don't know what's going on. Mr. Davis, can you try to enter the breakout room? Mr. Davis, he can try to enter the breakout room again. I think he's in there now.
Okay, thank you.
Well, they get you on
Did
two
the
devices.
invitation again, it kicked us out last time.
Oh, you're on 2 devices? Let's see here. Let me try that. There we go. There we go. All right. All right. On the record, State of Michigan versus Tony Davis case 25045942201. Today is the date set for bond redetermination hearing. Mr. Reagan, your appearance, please.
Reagan, on behalf of Tony Davis, Your Honor, who's here for bond redetermination.
All right, bond is set intentionally unaffordable. Mr. Reagan as to bond.
Judge, my client's on parole right now. He's actually on parole placement. So we're asking, of course, this is a retail fraud matter. We're asking for a personal bond. He already has a tether on from parole, and he's in a placement living facility. So what parole would do, if you get him personal, parole would come get him, and they would put him back in his placement, and he would still be monitored, Judge. So that's why we're asking for a personal bond for this retail fraud matter.
I don't know if I can give a personal because was he on bond or warrant status for another retail fraud? It looks like a ticket
I don't.
that was issued in May. But as it stands, he's not going anywhere. So what I'm going to do is set bond at $10,000 personal GPS tether house arrest to wherever he can tether to while this matter is pending. No contact with the Myers on 8 Mile while this matter is pending. And then hopefully he can go back back to the other placement. Mr. Davis, you do have a preliminary exam before
Judge Bryant.
I messed up. So you have a pretrial before Judge Bryant on August 26th at 8:30. August 26th.
We'll be there.
All right. That concludes the hearing.
Thank you, Judge.
Gentlemen in interview room 52, can you tell me your name?
Donald Graham.
One more time.
Donald Graham.
All right, thank you, Mr. Brown. Or Graham. State of Michigan versus Donald Graham, case 255922001. Today is the date set for a bond redetermination hearing. Appearances, please.
We'll bring it on behalf of Mr. Graham, Judge, who's here for bond redetermination.
And Mr. Graham, good morning, sir. Could you state your name for the record?
Donald Graham.
All right, thank you, Mr. Graham. Today is the date set for redetermination. Bond was set intentionally unaffordable. Mr. Reagan asked the bond.
Judge, the bond is $500,000 cash right now. My client's 21, Judge. He's a lifelong resident of the city. Obviously, these matters are serious. Judge, to point out, Judge, and I know the court already knows this court, because he has a remand on another matter out of Judge J.K. So I'm asking this bond be reduced to something substantially lower than $500,000 cash, Judge.
1 second. All right, I would note that Mr. Graham is on a remand order from Judge J.K. on a case that bond could be denied. This matter is later in time than the matter that was up, that is up before Judge J.K. 1 second here. I would also note, though, that I have a violent assaultive history in cases involving Mr. Graham as well, enough that this matter could been remanded as well due to the nature of the charges. Bond is set intentionally unaffordable. I'm not going to deny bond, but I am going to keep it where it's at due to the violent history. I have this matter, which involves a person that is known to the defendant. I have a later in time matter where the defendant is charged with a murder, and I have an assault history here. This bond is more than appropriate. Mr. Graham, so next date is before Judge Jefferson on August 27th, 2025. August 27th, sir, for a PCC. That concludes the hearing.
Thank you.
You're welcome. Gentlemen in interview room 10, can you tell me your name?
Dwayne Simmons.
You said Twain Simmons?
Yes, sir.
All right, State of Michigan versus Twain Simmons, case 2505946. 2301. Today is the date set for bond redetermination. Mr. Reagan, your appearance, please.
Philip Reagan on behalf of Mr. Dwayne Simmons, reading stand mute. Been advised of right, Judge.
All right, today is the date set for the redetermination hearing. Bond is set intentionally unaffordable. Mr. Reagan, as to bond.
Judge, I would point out that the bond is $2,000. It's a substantial bond for Mr. Simmons, Judge. He can't afford it. He's 24. He has no prior criminal history to my knowledge whatsoever, Judge. Does suffer from certain medical issues. No children, Judge. Lives in the city of Detroit, has strong ties. But based on the fact, Judge, he has no criminal history, I would ask the court to consider reducing the bond to $20,000 personal, whatever condition the court did wish to impose, Your Honor.
All right, thank you. The defendant and the complaining witness are related and I believe have similar addresses. Is there an alternative place that Mr. Simmons can stay?
Mr. Simmons, you can go to another location. Is that correct?
She don't live there. Okay, I can say something. I can say something.
He was saying she doesn't live, Judge, but I know that the court would want him to go to another location.
Yes.
So you need to go to another location, Mr. Simmons.
Okay.
Where is that going to be?
I don't know because that's my I live that's my girlfriend mother house. She just came there. She just came there to stay there for like 2 months and that's it. She don't got no mail, no ad. She don't got no mail, none of that going to the house.
Okay. 1 second.
Okay. You have my show.
All right, I'm setting bond at $100,000 personal with the GPS tether, no contact with Miss Simmons and no contact with whatever address Miss Simmons is staying at while this matter is pending. Mr. Simmons, your next date is going to be August 11th. Strike that. Next date is going to be August 28th, 2025 before Judge Giles. My other condition is not allowed to stay in any place where animals are present. And that's a condition of the bond. Yes, sir.
Thank you, Judge.
Since that means I can go back to my house or no? Because she don't live here.
If she's there, you can't be there.
Okay. Okay.
All right, that concludes. And if there's animals there, you can't be there.
Okay. I understand, sir.
All right, that concludes the hearing. Gentlemen in interview room 52, can you tell me your name?
Jermaine Mitchell.
All right, thank you, sir. This is State of Michigan versus Jermaine Mitchell, case 17056476601. Today is the date set for redetermination. Bond is set at $150. Appearances, please. Mr. Reagan.
Philip Reagan on behalf of Mr. Mitchell, Your Honor. I was present for bond redetermination.
All right, today is the date set for bond redetermination. This bond was set by Judge Edwards on December 22nd. I'm going to amend this bond to $20,000 personal. Mr. Mitchell, you got to make your court dates. We're still going to keep arresting you as long as you're missing these dates.
Okay.
It's not going to go away.
All right.
Sir, your next date is going to be September 10th, 2025 before Judge Edwards. And that's at the new Criminal Justice Center.
All right.
All right, that concludes this hearing.
Thank you.
Thank you, Judge.
Wait. To be sure, that's Mitchell, Mr. Mitchell. All right, you're all set, Mr. Mitchell. All right, interview room 11. Can you tell me your name?
Freeman Wright.
Freeman Wright, and gentlemen are in interview room 52. Can you tell me your name?
Banks.
All right, I'm going to do Mr. Banks and I'm going to do Mr. Wright. This is State of Michigan versus King Banks, case 25059392001. Today is the date set for a bond redetermination hearing. Appearances, please.
Good morning, Your Honor. Nicholas Davis, P88380 on behalf of the people.
Judge Philip Reagan on behalf of Mr. Banks, who's here for bond redetermination.
All right, and good morning, Mr. Banks. Sir, could you state your name for the record?
King Banks.
All right, thank you, Mr. Banks. Today is the date set for redetermination hearing for the people. Go ahead.
Thank you, Your Honor. In this matter, this involves a carjacking and felony firearm. The victim in this case was forcibly removed from his vehicle at gunpoint and was threatened with being shot if he did not turn over the keys to his vehicle. The people have serious concerns as to the danger presented to the community by the defendants in this case. I would note firearms were recovered from the defendant's residence when the state police executed a search warrant in this matter. It's for those reasons we would ask that bond remain as is.
All right, Mr. Reagan has the bond.
Judge, you know, like I said before, he's 18 age. The allegations are obviously serious. He works with his uncle, Judge, does electrical and plumbing from 6 a.m. to 5 p.m. Monday through Friday. So he's up and out doing something productive, Judge. So I'm asking the court respectfully to reduce the bond. He lives in the city of Detroit, so he has ties, Judge. Again, he's 18. I would go over my knowledge, Judge. Does have some juvenile, but I would ask for a reduction in bond.
All right, I've had a chance to review the investigator's report in this matter. I would note that this is not only an assault of crime, but a crime involving a weapon. And I would note that the allegations, as stated, was that Mr. Banks, and these are allegations because they have to be proven, and the people have to, prove beyond a reasonable doubt, did in fact threaten a driver of a motor vehicle, an Uber driver, threaten him with the understanding to try to take his vehicle. I do have concerns for the safety of not only that person as well as the community. This was a person that was not known to the defendant. So I'm going to keep bond intentionally unaffordable where it's at $100,000 cash or surety, all conditions set by the magistrate at the arraignment continue. The next date is going to be before Judge Giles on August 27th before Judge Giles, August 27th for a probable cause conference. And that concludes this hearing. You're all set, Mr. Banks.
Thank you, Judge.
You're welcome.
Thank you, Your Honor.
Thank you. All right. And then we had, what's the other person? Mr. Wright, can you hear me, sir?
Yes, sir.
This is State of Michigan versus Freeman Wright, case 25059-34701. Today is the date set for a bond redetermination hearing. Mr. Reagan as to bond.
Just give me one quick second looking for Mr. Wright's stuff. Judge, and as to bond, Judge, Mr. Wright, Judge, is 47 years old. I do understand the nature of the charges, Judge. It's they're obviously disturbing, Judge. My client's been here for the last 13 years, Judge. Gets SSI, no prior criminal history to my knowledge. So I'm asking for a reduction in bond. We did mark it biomedical. But again, Judge, I'm asking the court to reduce the bond.
All right, I've had a chance to review the investigator's report, and I would note that Mr. Wright does not have a criminal history, at least that I can tell, before this court, and none have been presented. However, the allegations in this matter are of an assaultive nature, a very disturbing assaultive nature. I would note the arrest was made pretty contemporaneous with the alleged assault. This kind of takes place within close in time. And I do believe that there has been a danger created as these folks were strangers, and when the business deal didn't go as planned, the assault took place. Bond is going to remain intentionally unaffordable at $50,000 cash as surety. I would note the file is marked medical, and I've made a note as well to make sure that Mr. Wright gets the medical treatment that he needs while this matter is pending. Next date is going to be August 29th before Judge Jacquet. Strike that. Next date is August 22nd before Judge Jacquet. August 22nd, and that's a probable cause conference.
Thank you, Judge.
You're welcome, and that concludes the hearing. Mr. Wright, you're all set for today. Gentlemen in interview room 11, can you tell me your name?
Samuel Simmons.
All right, this is State of Michigan versus Samuel Simmons, case 2305806-801. Today is the date set for a bond redetermination hearing. Bond is set intentionally unaffordable. Mr. Simmons, sir. Actually, Mr. Reagan, could you put your appearance on?
Philip Reagan on behalf of Mr. Simmons, Honor, who was present for bond redetermination.
And Mr. Simmons, could you state your name for the record?
Samuel Simmons.
All right, thank you, Mr. Simmons. Bond is currently set at $500. Mr. Reagan asked to bond.
Judge, this was a capious matter. With Judge Tate, the matter goes back years. He was in a psych hospital. My understanding back at the time. So I'm asking for to consider reducing it to a person. Whatever other conditions the court wishes to impose, Judge, we have no objection to, but I would ask the court to reduce it to a personal based on the age of the case. And the fact that the bond is judged is 500, but I think a tether was added with the curfew as well.
Do we know where Mr. Simmons is staying?
Judge, he has an address in Detroit right now on Minnock. That's the current address. He lives with his uncle. So that's my understanding at this time.
All right, I'm gonna set the bond at $10,000 personal with the GPS tether while this matter is pending. Mr. Simmons, sir, you have no weapons while this case is pending. Do you understand?
Yeah.
All right, Mr. Simmons, your next date is going to be before Judge Taylor, and that's going to be August 27th, 2025, before Judge Taylor, August 27th.
Okay.
Thank you, Judge.
All right, thank you, Mr. Simmons.
Okay.
Don't shoot the messenger, but 134 just called and said they have
Hi, interview room 52. Can you tell me your name?
Hi, this is Chelsea Smith, and magistrate for Henry. I don't have anyone else. If you wanted to kick them off the camera, 4H is done.
Oh, okay. Thank you.
Thanks.
Hey, bro.
Hello, how are you?
All right.
All right, this is State of Michigan versus Chelsea Smith, case 25055984001. Today is the date set for a redetermination hearing. Appearances, please.
For the record, on behalf of Ms. Smith, Judge, who's here for bond redetermination.
Bond is set intentionally unaffordable on this matter after a capious. Mr. Reagan asked to bond.
Judge, as the court said, these are capious bonds. My client's 31, no kids. Judge isn't working right now to my knowledge, but also is not on probation or parole. We just need to make sure she gets to court, Judge. That's all. And maybe, whatever the court wishes to do that, Judge, we'd understand. I just don't think a cash bond is necessary. I don't think the Wayne County Jail is necessary for Ms. Smith. So I am asking for a reduction in the bond, Judge, but whatever condition the court imposed, we would not object to.
1 second.
Get to the court.
Where's your client living at right now?
Judge, she is currently living
with my best friend
in Detroit on Schaefer.
Gonna set bond at $10,000 personal with a GPS tether. Ms. Smith?
Yes.
Missed your court dates. We're gonna continue to arrest you. We're gonna have to address these every single time. Gotta make your dates. Nothing else I can tell you about that.
Okay, so what is my court date?
Your court date is going to be August 28th, 2025, before Judge Taylor.
Okay, is that in person or Zoom?
I believe that first one's gonna be on Zoom, but if you
Okay.
can't make it on Zoom, you need to come down to court.
Okay, so I have a personal bond with tender.
Personal bond with a tether, no contact, with,
Good deal.
Trying to see what you say.
no contact. Was that a gas station on Schaefer, 8,000 Schaefer Highway?
That's a.
Family Dollar.
It's Family Dollar, okay,
Can't be there.
okay,
I'll remand you if you're caught in there again. All right,
thank you.
that concludes this hearing.
Okay, God bless you, thank you.
Thank you, Judge.
Good luck, ma'am.
All right, sir, this is Miss Kara Mahone, or Mahone.
All right. Ms. Mahone, can you hear me?
Yes.
This is State of Michigan versus Kara Mahone, case 25059-41801. Today is the date set for a bond redetermination hearing. Bond said intentionally unaffordable. Mr. Reagan asked to bond.
As the bond judge, my client's 33, doesn't have what I can see any assaultive history whatsoever. Not working at the present time, judge, no kids. She lives with her father in the city. So I am asking for a reduction in bond. For personal bond is 50,000 cash as surety, judge, but I am asking for personal, whatever conditions the court imposed.
All right, 1 second. All right, I've had a chance to review the investigator's report. Ms. Mahone in this matter is charged with some pretty serious offenses, and bond is set intentionally unaffordable. 1 second here. It's also my understanding that Miss Mahone is currently on a bond status for another violent offense. This is a matter that bond could be denied. It was said intentionally unaffordable, and I'll keep it intentionally unaffordable, but I'm not going to remand Miss Mahone at this time. We'll leave that to whatever they're doing in the circuit court on that case. But mine is going to remain intentionally unaffordable. The next date, Ms. Mahone, is going to be August 26, 2025 at 8:30 before Judge Jefferson, August 26. That concludes the hearing. All right, gentlemen in interview room 15, can you tell me your name, sir?
Gerald Green.
All right, thank you, Mr. Green. This is State of Michigan versus Gerald Green, case 25059367001. Today is the date set for a bond redetermination hearing. Appearances, please.
Judge Philip Reagan on behalf of Gerald Green, who's here for bond redetermination.
All right, thank you, Mr. Reagan. Mr. Green, today is the date set for the redetermination, bonds and intentionally unaffordable. Mr. Reagan has the bond.
Judge, Mr. Green's 38, has 2 kids, lives in the city of Detroit. So he has strong ties to the city. Judge, I understand the nature of the charges are very serious. Bond set at $500,000, which we think is excessive in this matter. Judge, I do understand there's some history here. But my client's employed every day at Detroit courting, Judge. He drives semi-trucks, so he has a steady job. And that's the most important thing I want the court to understand. He has kids, he has a job, and these are just allegations right now. We're early on in the case, so I'm asking the court respectfully. We think that the $500,000 is excessive, very excessive. So I'm asking for a reduction to a personal bond, Judge, so that he can go to work. I know you may put a tether on him, that's fine. We just want him to be able to go to work, support his kids, not lose his job because of these allegations. The case is going to play out in court. He'll have his day in court. And, I think that the true facts will come out at that time. But right now, I'm asking for a reduction.
All right, give me one moment. I've had a chance to review the investigator's report. I would note that, actually, one second. You gotta see one more thing. Okay, I've had a chance to review the investigator's report. These are serious and assaultive allegations. And I would note that while these are allegations, and of course, Mr. Green is innocent to proven guilty and is and remains so until proven as such, I have to consider the safety of the public in this matter. There are allegations that Mr. Green was at a location, got into a dispute, came back to the location, and then proceeded to engage in the assault. Bond is going to remain intentionally unaffordable. These are folks that knew each other. This is an address also familiar with the defendant, and for the safety of the community as well as the complaining witnesses, everyone in that house. The bond is going to remain intentionally unaffordable. Mr. Green, your next date is going to be August 21st, 2025, before Judge Jefferson.
All right.
Thank you, sir.
All right.
Thank you, Judge.
All right. I am going to step off. I believe you're going to have the judge assigned to complete the rest of the docket. Give me a call if you need me. I'll meet you in 134.
We got one more.
When you got one more, I'll do one more for you. Who's the defendant here?
Deshaun Maurice Johnson Williams.
All right, thank you, Mr. Johnson Williams. This is State of Michigan versus Johnson Williams, case 250592201. Today is the date set for bond redetermination. Appearances, please.
Judge Philip Wright on behalf of Mr. Deshaun Johnson Williams, who's here for bond redetermination.
All right, Mr. Reagan as to bond.
Judge, this is a situation, bond's $25,000 cash surety. This is a situation, Mr. Johnson Williams has kids with Miss Ray, and he tells us that she's very, very bitter at the way their relationship ended. He has evidence, Judge. He has evidence in his phone that shows her attacking him on several different occasions. He works every day as a contractor, does home improvement, Judge. So he's not wanting to have contact with her. I mean, this incident date was allegedly back in June, wasn't signed by the prosecutor until August. So, Judge, there are a lot of things that we're going to be refuting here. But right now, I think that the court could use a lesser measure, Judge, to keep everybody safe with a tether and a personal bond. He has a curfew already set in place. It would work for his job so that he can support his kids. But again, Judge, when you have, situations like this, there's two sides to it. But to err on the safe side, a tether would be okay here, Judge. But I am asking the court respectfully to reduce it to personal bond based on our conversations with Mr. Johnson Williams about what really happened, Judge.
Well, these are allegations, but this doesn't take place at his house. This takes place at someone else's house. There's a firearm involved with this as well. And, people outside of the folks who are involved with this assault are witnesses as well. So, they're gonna resolve themselves. Whether they're gonna resolve themselves, I'm not here for that. I am gonna reduce the bond. Give me 1 second. But 1 second here. I don't have any other DV incidents. I'm gonna reduce the bond 25,000 personal with a GPS tether, no contact with Miss Ray while this matter is pending. Do you understand, Mr. Johnson Williams?
Yes.
Thank you, Judge.
Sir, if you're over that way, I got no choice. I'm gonna have to remand you, and you just be in custody until this matter resolves. Next date's going to be August 28th, 2025, before Judge Giles. I don't understand why this is not in Judge Shakay's court, but if it is what it is, we'll keep it with Judge Giles.
Thank you, Judge.
All right, that concludes the hearing.
Madam Clerk, how many more do we have, actually?
We only have one left, and that's Mr. Bamford. The other two, Porter and Tillman, bonded out. So
Okay.
that leaves Bamford.
You know what? Can you do me a favor?
Deputy?
Hey, Madam Clerk, you all set with Mr. Williams?
Yeah, we're all set with him, and then we only have one defendant left, Mr. Demetrius Bamford. Are you bringing him to?
You said Sanford or Banford?